He's a contractor, a glazing contractor in Norwalk. So for any comments and concerns of any person present today, I think we should start with Joe.
Sure.
Joe, let's start with you. And maybe you could present the case as you see it.
Okay, it probably would be more for Jason because he's down at his end of the world, but we had a contractor down at Charter Communications who called us a while back about some glass work, and they're coming out of New Jersey. I think, Jason, you want to tell the story? It might be better from you.
Yeah, like as Joe was saying, it's Charter Communications, company coming out of New Jersey, called us about doing glazing work, interior. You know, I explained the process to him, the licensure for the employees and the employer. He wasn't going to do the job. He looked on DCP website and he understood what I was talking about. He then told Transwall, the manufacturer. Transwall reached out to Norwalk Glass to bid the job, and they were in the process. And last minute, something went sour, and they're down there installing the glass. Supposedly DCP sent Transwall an explanation that you do not need a license to install this glass, and that's where we're at.
Julianne, are you aware of that?
I am.
Okay.
So what happened around this time is that we had investigators go out to get some more information on the status of the work being done there. Ultimately, fast forwarding through a number of communications, I was consulted about what we wanted to do about this case. There was so I typed up kind of a response on this. There was a bit of miscommunication about whether or not specifically this was licensable work. So my response essentially related to whether or not these people needed a license or what we were going to be doing about this case is that I asked a number of questions about what the substance of the case was. Was it glass with unfinished edges? Was it interior glass that was in a kit? Was it, like how was essentially it being handled? A number of questions to really determine what the public health and safety issues were related to this project and the impact on consumers and the general public. Based on this assessment, again, taking it away from licensure, what I had determined is that this is not an enforcement priority for the department. With limited resources, we triage cases based on public health and safety. So I had communicated that this is not a case that DCP would be taking for enforcement. What went back to Transwall was that this is not licensable work. What my email also said was that it is unclear whether this is licensable work. This is the reason that for years now we've been talking to the board, and again, even going back to 2017, which is the email which are the minutes rather, that Joe Vizino sent back and said, well, what about this? And they were also included in Jennifer's email as well, related to, whether or not it was glazing work, the confusion that was happening related to the regulations at that point. We hadn't started talking about statute yet, but about what glazing work encompassed and what pre-glazed was. So my email to the team said, until we have some further clarification on what the scope of this is and what the legislature intends us to actually do enforcement on, what they consider a public health and safety issue, this is not something to us that rises to a level that we would be doing, that we would be triaging this above other cases. And so I gave instruction to the team to take no further enforcement and to inform the business, though, that they should be reviewing the law and adhering to it. And so, again, the way that they took that was, and since they also had an email that said they don't need a license, they proceeded forward without obtaining without subcontracting rather to a licensed glazier company.
Okay, now, every few years, we have to give a dog and pony show of what we do as glazers after 3 years of an apprenticeship. In the case of the union glazers, it's a 4-year apprenticeship because there's welding and stuff involved. And once we do that, the folks that are knowledgeable and showing the people that are not as knowledgeable, AKA DCP, we show them and they understand it, and then they get a better idea of what we're doing. When you have a glass company bidding that work, I wouldn't think he'd be bidding it because he thought it was not essential or not, part of his scope of work. So I just don't understand
I
why.
can I try?
Excuse me.
Nothing. When I get a moment, I'd like to say something. That's all.
Okay. Where's Julianne? Oh, there she is. Julianne, I'm trying to address it to you. Not you personally, but the department that you represent, okay?
Absolutely.
We've been through this. I've been on this board for 18 years trying to get our regulations or laws documented so that we know when the inspectors go out, they know exactly what they're looking for. But like I said, every few years it changes. So we've got a bunch of people here, a group of people, panelists, that do this for a living. And we have pictures of what the job consists of, which is things that our apprentices are taught to do while they're working as an apprentice and go work to a journeyman status. So, I mean, we're a little upset about this, as you can tell. But like I said, I've got people here that there's probably 200 years experience on the board right now that are talking to you. So, Carl, you would like to add something?
Yes, in the response, it says that they're installing frameless pieces. There should be no confusion because frameless is not pre-glazed. Doesn't matter if it's load bearing. It doesn't matter if it has finished edges. It's not pre-glazed. It's frameless. It's the most dangerous point of where the glass could be. It's just so contradictory to the description of what the work is.
But one of the
Hey, this
things
is
we discussed-
Mark Jr. from Norwalk Glass Company. We're the licensed glass and glazing contractor for the charter project, and I think this project is the epitome of what we do and why we are licensed to do glass and glazing. And Carl, you hit the nail on the head. This is a stick system that has uncaptured glass that is glazed in the field. It's not pre-glazed. It's not, for say, lack of a better term, a demountable wall system, because as far as I'm concerned, that's just how the accountants do it to get their tax in line and stuff like that. But I mean, this is a stick-built glaze in the field system. Just because the edges are polished doesn't give an unlicensed person the right to put this in. It's definitely uncaptured glass, which is what we carry our license for.
So the question of furniture and furniture packages, which is again how the architects and accountants certainly do qualify this most times, that has a finished edge. That is something that we talked a lot about over the last few years. And that's what we have pushed the board and the trade professionals to go to the legislature and get some clarification on as to whether or not this is encompassed. Because when we're looking at cases, again, we look at them for public health and safety issues. And the idea that handling, for example, I'm sitting in my office right now, there is a door on my office that is not set within a frame, yet I touch the edges of it every day. That it was part of a furniture package that just needed to be mounted onto the wall. I'm assuming, because we're the state, I'm hoping that they went through and that they used licensable tradesmen or licensed.
They didn't, and that started this whole contention. They didn't, and that was what started the process rolling on how to figure this out.
They ended up using licensed guys to install that glass once DCP went in and looked at it. So yes, they did use licensed guys once we found out that it wasn't being used the right way.
Another time, guys.
Yeah, so in the future, I mean, one of the things is that we certainly can provide more clarity for the industry as to what is, what may fall under a license. But, what I made very clear to our team was that this would not be an enforcement case. So one of the things that sometimes we do here is that, we may find a home improvement contractor that's not registered, but we find, whether there's minor violations in their contract, that their van doesn't have a home improvement contractor number on it, that there are technical violations of law. They're not violations of law that impact public health and safety. Then we are not going to triage those for enforcement. And as you guys know, it's a frustration of many in the industry, not just with glaziers, but throughout occupational trades in general, that unfortunately we don't have enough inspectors to get everywhere. We don't have enough inspectors or lawyers to be able to take all the cases. And so we have to triage them. And as the questions that I asked related to what type of work was being done at the site satisfied me, that said that this is not a public health and safety priority. And if we are going to make this more of an imminent, emphasize an imminent threat in this industry, or say that this is something that needs greater enforcement priority, that's something we need direction from the legislature. And that's something that we've been saying to the board over and over. Leslie O'Brien attended the last meeting, I believe 2 or 3 weeks ago, and repeated the same thing. So, I mean, that's really where we stand today.
So you don't consider the people that work in that office part of the public? Because that's public safety right there. If it's installed improperly and you go to slam that door one morning and that thing just shatters, even though it's going to shatter into small pieces, if it's tempered glass, it's still going to cut you. And that's part of the public safety right there.
But if it was a wood door and it was installed improperly and it fell on me, it would hurt me just as badly.
You would go off after the carpenter, but
yes, but they're not licensed either. And so we wouldn't say that this is such a public health and safety issue that we
really
need to.
Is stuff.
But that's not something that the legislature has determined and clarified for us. And so we don't.
Oh, they did determine pre-glazed and glazed, and those are not pre-glazed. There's no gray area there. There's no gray area. There's
for us, the gray area is, if this is a finished product. Is this a finished product that needs further handling?
Is there any way that we can share those couple photos? I'm trying to see on this chat. Is there any way we can send this photo to does Zoom allow a photo share on this?
Yes, you mean screen share with the green?
Go to screen share?
The green screen share button at the bottom of the screen.
Okay, all right. Because I think, just give me a second here. Okay. Share screen. Host has disabled attendee screen sharing.
I'm trying to get this.
Yeah,
I believe I have their shop drawings, Transwell's shop drawings. I'm trying to pull them out right now also.
Thank you, Mark.
So just to clarify, the state went out and inspected this job site. It wasn't done it was an actual site visit.
I'll have to confirm. Pam, you're still on. So
here's a photo of the site with the metal leaning up against the walls and no glass in it. So I would like somebody to explain to me how that is pre-glazed, meaning the glass is already installed in those frames.
No, I didn't say it was. I said the same thing with my door right now, that it is never going to be installed within a frame, and that many furniture packages now are assembled in terms of.
This glass isn't a door, it's installed in a frame.
Okay, but so is there's also a frame that's here, that again, with finished edges, and it's installed in a kit.
But it's not pre-glazed.
Pre-glazed, meaning the glass.
Our law says pre-glazed.
And we have had
that's
years.
Not pre-glazed.
Yeah, we've had years worth of conversations about this. This isn't a new subject that we're discussing today. And what we've said over and over is that we need legislative clarification as to what their intent is related to the scope of this work.
Well, because according to the email from Matt Sargent, he said the department has concluded the installation of interior frameless glass doors in this case does not constitute glazer work and does not require licensed glazers to perform installation. Transwall has confirmed the glass at issue is not load bearing and the edges are polished and require no further glazing on site. Based on the specific circumstance of this project, licensed glazers are not required for this installation. It's it's more than just doors. They couldn't have inspected the site. And now I
It
feel
required further glazing
going on here. If the glass that comes in a crate and they have to take it and put it in the opening, that is the verb and the action of glazing. So
again, there are two issues here. The first one being, again, I apologized already that it is from my initial communication out to our team to what then was communicated to Matt Sargent. There was a miscommunication as to whether or not this was licensable work. My message really was that it is unclear whether this is licensable work, that there is not a final determination as to whether this is licensable work. And so the secondary thing is whether or not it is an issue of public health and safety. And so even if there was consensus as to whether or not this was licensable work, the second part of this is whether or not DCP would have taken further enforcement action. And it's my determination, based on the information that was provided, again, about having polished edges, about whether it was load bearing, about whether it was interior glass in a place that was occupied, all of these different factors contributed to an assessment as to whether or not this is a public health and safety risk that would require us to triage it above other projects. And that was my determination that no, this would not rise to the level of something that we would triage again above other projects or other cases that we have that are more imminent risk to public health and safety.
But if DCP is not going to back our board, we are no longer needed here. Because that is our work. It's part of our training. And if DCP doesn't not want to back us, we have Jessica on who runs a training program. Joe's here who is part of a training program with the union. Union contractor, we have regular contractors here. We have people that have been in the business. And then when we got this law to protect the public because we knew what we were doing. Now if the DCP does not want to protect us, I don't know what we're doing here.
I'd like for the department to tell us, instead of us telling them what our work is, why don't they tell us what our job is? Because we obviously do not know what glazing work is. So maybe the department should tell us what their opinion is as to what a glazer is. What is an FG1 and an FG2? What is their job? Because I
would like further clarification from the legislature. Because when it comes to what the intended scope is and protecting the public, which is generally why the legislature sets forth laws, is deterring economic harm, ensuring public health and safety, and promoting the marketplace, that's where we need further guidance from the legislature.
Well, after all these years, we tried to get our regulations in, and finally the DCP said they didn't want to have anything to do with it, because that's what they said. Go to the law, and let them decide, because they didn't want to decide it. They didn't want this hot potato any longer.
Well,
that's what's happening.
That there's a huge difference between regulations and statutes. And with regulations, what we're doing is we're generally putting guardrails around what the statute says. So for example, we have the legislature authorizes medical marijuana. And we say, okay, well, the laboratories have to test to this standard, or they have to be this far away from a school. So we start doing all of the minutia that the legislature gave us, a broad policy, and now we're tasked with doing certain things. However, if there's a question of what was intended, generally, we don't like to interpret what the legislature, especially if it's been a long period of time since the legislature contemplated a certain issue. It's not our place to say, well, this is what they intended. Even when it comes to doing a declaratory ruling on a matter, when it comes to statutes, We don't get to interpret statutes. We get to state how we've been applying them. Regulations that the department sets forth are the only place that we can interpret the meaning of them. So rather than interpreting the meaning out of school, which we're not allowed to do for statutes, we want to defer to those lawmakers that set the policy in the first place.
No, because it's in the statute. It seems like you're the one who's interpreting it differently.
Well, we're saying
In other
that
words,
there's
it's in the
confusion.
statute. It's plain as day. There's no interpretation. If you open up the Webster Dictionary and look at the definition of glazing, why are you trying to change it? In other words, it's there. It's in writing. You have panel experts. You have people in the trade. It's not about trade. It's there. It seems like the miscommunication or the interpretation is coming from your office. In other words, nobody else is confused about it, only your office.
And as for the intent of the legislator, I think
We were there.
Kevin McMahon can attest to this. Jessica can, and so can Joe, and so can Ed Fusco. The reason why the Glazers Law came into existence is because of the Connecticut Glass Dealers Association, the independents, and the Glazers Union. Both union and non-union come together, put together a bill, and presented to the legislator and got it passed. So our actual trade saw a need for this and petitioned and went through the system and got the law passed. And I know I've asked this question numerous times and nobody seems to be able to find the paperwork. But if you go back to when our bill had the initial public hearings, back when was it? I don't know what year, 2000, or maybe it was in the late 90s.
99.
99. Our bill had some opposition by, I believe it was either the Home Builders Association or the Carpenters, possibly. I'm not sure which one. And their opposition was that you need to add in a pre-glazed window and door because we want to make sure that in a residential application, the square foot exemption applies to the size of a patio door. And that was why that got written in to our bill. And if we could pull that transcript from that time, we would know the exact answer to Julianne's question, which is what was the intention of the legislator for our bill? And that exemption was to exclude the vinyl windows, the aluminum windows, a pre-glazed window and door, period, end of story. This polished edge nonsense, we've beat it to the point of no return. So if our board, who is supposed to be the SMEs, is being discredited and saying, no, because that's polished edge, oh, it's furniture, the IRS says you can, this is nonsense. It's absolute nonsense. We don't need the legislator to tell us, who doesn't do our job, to tell us what our job is. That's it. It's ridiculous. It's frustrating. For almost 20 years, we have been beating this. Do regulations. We try to do that. We wrote all the regulations, meeting after meeting after meeting. Oh, no, now it has to go to the legislator. Oh, no, not the legislator. No, it's got to be regulation. We've had demonstrations. We've brought in samples. We've had meetings. We have independent people, non-union, union, all these people saying this. And we're being told, no, because it's got a polished edge, it's pre-glazed. Okay.
So the law was set forth related to this. And Leslie will be joining us. I know, well, she is on, but she's unable to speak right now. But I can just say that the legislature passed the definition of automotive flat glass and then also flat glass work in 1999. So 11 years, oh my goodness, 21 years ago, I can do math, see my second cup of coffee. So 21 years ago, there was a law passed. And at that point, it doesn't appear that some of these furniture packages, the way they are used today, were used. That it seems like possibly that the industry has changed. We see this very often. We see this with plumbers. All of a sudden, we have go from copper to PEX over time. We see this with this is common in all different trades, that the industry shifts over time. And so there are certain things that aren't contemplated, and oftentimes we go back to the legislature in the event that there is any kind of confusion about what needs to be included, what does not, and ask them to provide us with additional guidance. Because also, one of the things that's difficult is that in the event that something changes, sometimes that means that it also requires us to do more enforcement. And that means more resources. So we go back to them and say, is this expanded scope, this new shift in the industry, is this something that you want us to prioritize? Because if you do, this is the impact on our department. This is what it would take for us to do it properly. And if you don't provide us with resources, this is what it would take away from in terms of our other ability to do enforcement in other areas. So that's why this is not a unique issue within flat glass. This is something that we see as the world changes.
But do you think, I know I don't think, that Mr. Sergeant goes on the job site, looks at the job site, sees that there's glass going on outside, takes 5 minutes to walk inside, see that it's glass going inside also, and the impact on you is an extra 15, 20 minutes, half an hour.
How long did it take him to get there? And then when he leaves, how many reports did he have to write up? Then how many conversations did he have to have with my legal team to decide whether or not, and before he has conversations with my legal team, how many conversations did he have to have with Janita and Janita with Pam? So it all aggregates. This is never going to be 15 minutes of Matt's time. And if Matt spent 15 minutes there and then left it alone, it wouldn't be a case. And he's more thorough than that. And therefore, every bit of this adds up. And so that's why we can't get to all of the different sites, and we have to prioritize the work we do.
I mean, this is a 15-story building. I don't know how this couldn't be at the top, wouldn't be at the top of the priority. This isn't a small project. This is a few $1 million glass and glazing package.
But it's not the size of the project, it's the type of work they're doing.
But there's no, I know you say things are ever changing. There's nothing changed. This is a system that we've seen for the past 30 years. This is a stick-built framing system that is being field glazed with loose glass. There's nothing new. And just because Transwell says, oh, this is our new system, doesn't mean that in our industry, they haven't reinvented anything. Maybe the extrusions have changed a little bit. But this is essentially, this is an unglazed system. This is the epitome of why we are licensed. And it takes 15 minutes for somebody from the state to go in there and realize it. But nobody's gone there.
As I've explained, it never takes 15 minutes.
All right, we're going to let Leslie jump in because I know she has been anxiously awaiting to give us her legislative proudness. Leslie, are you still there, or are you?
Oh, yeah, I'm finally, I've been here the whole time, just unable to access, but now, thank you. Somebody fixed something, so here I am. As I mentioned at the last meeting, last session, someone had a bill raised. We were very clear that we would not weigh in one way or the other, but the bill would clarify what is licensable and what is not, because the statute is ambiguous and we need better clarification. We are not the policymakers. We are the regulators. We're supposed to enforce laws that the legislature passes. And I know there's a lot of frustration, and there has been for years, about this issue, but we really need someone to tell us from the legislature what the intended policy is here, because it is not clear. And in fact, that is also evidenced by what happened last session, where when the language was brought to the General Law Committee, they didn't, they weren't sure how to proceed. So, because as you know, and we all know, there's the unlicensed trades and the licensed trades. And in this instance, you all are the licensed trade we're talking about. And there's an ongoing dispute that we don't feel that we should be getting in the middle of, that we think policymakers need to decide. So we talked about this last, probably around a year ago, maybe more. Maybe it was summertime. We were in the big conference room with some people who were on this call.
2017.
I'm sorry? No, I'm not talking
was
about then.
2017.
No, Jennifer, I'm talking about last year. We had a meeting, I think it was with the union. It was with multiple union members who were involved in the licensed trades. And at that meeting, at the end of the meeting, when this issue came up, I said, I really think we need the legislature to clarify what their intentions were and are with respect to what is licensable work in this arena and what is not. And I spoke with Kim Glassman as well, and I think she's here somewhere too. And I said, we're not going to take a position on the bill. We just want clarification.
So we need to educate the legislatures, as we did with the Department of Consumer Protection, with either a dog and pony show or a job site visit or something to that effect, because just saying what we do doesn't get through to them. And we could see that now that it hasn't. Obviously, you guys understand a little, and that's why you're staying neutral, because you understand what it is, but you just don't want to be involved in the middle of it.
Right. Well, we need to be told what to regulate and what not to. We really do. And we need that direction. And I know you're all frustrated, and I'm sorry about that. But we really want the legislature to weigh in here, because we shouldn't be establishing policy. That should, not this kind of policy. That is not what we should be doing as a regulatory.
I have a question. Do you think the confusion is coming from, we sat collectively as a board and canvassed other industry professionals and came up with a definition of what we wanted to submit, and then the definition was totally rewritten and then submitted? Do you think because it was rewritten is why it's confusing?
No, the confusion is because there are competing interests here, because once one way or another, whatever that language becomes in regulation, either it's licensable or it's no longer licensable, or whatever. I mean, it's licensable or it's not. And so either way, whether it's licensable or not, there are winners and losers in this arena. And so I know from last session that when language was raised, that then there were non-licensed trades that objected to the language. And that's the problem we're in. Somebody needs to make a decision here, and it really should not be the regulatory agency. It should be the legislature. So that's the challenge we face, is that a decision needs to be made about who's, unless you all can come to an agreement with the non-licensed trades who are part of this issue, somebody needs to come to an agreement and tell us what and tell us what the legislative either intent was from the legislature, or what it is now. But we are supposed to be enforcing the laws that are established by the legislature. And in this instance, it is not clear. And because of that, there have been these ongoing feuds, and we've been, thrown in the middle of it. And we really need the legislature to make a decision here. If you all can come to an agreement with the non-licensed trades who are, who objected to the language last session, and if everyone can get to an agreement, that would be the best thing. But the problem I see right now is that nobody wants to pick a side here.
Well, we can't come to an agreement because we give 3 years of apprenticeship on how to do this work. I don't believe the other trade, as you say, does that.
Look, I understand. but this is what the legislature.
And I understand your point, Leslie. I do. I really do.
We're sort of stuck in the middle, and I'm sorry that we are. And I'm sorry for all of you and for your frustration. And I understand it's frustrating. I am frustrated too, for the record.
It just seems that it's cut and dry to people in our trade, and the language in the original bill is still cut and dry between glazed and pre-glazed, because people in our industry know what that is. And it's frustrating to us
That-
because
people,
there's no
know-
wavering there. It's already there. It's just,
the language in the statute is not that clear. And in fact, you have your beliefs, you know from the industry what you think it is, but there are people in the
well, we were
trade-
there when we introduced the bill, and we were all
But
there
but
with the
I
intention.
understand,
We
but-
all know what it
But
is.
the language says what it says, and it's not clear in the statute. And that's the problem. And by the way, this is not the only example of when this happens. They pass laws and then say, go ahead, agency, you sharpen it up in regulation. And the problem is, sometimes that's simple and it's just sort of the additional detail in regulation that needs to be added. In this case, it was left then to the department to establish policy. And that's the problem. The statute needs to be more clear, and then we can establish regulations about how to enforce the statute. But the statute isn't clear enough right now. They left it up to the regulations and regulation to deal with this, and that's the problem. And it means that no matter what, we could flip a coin and put something before race review, but you know what's going to happen then? The fight's going to end up at the race review committee, and then we're picking a side about which language we put there, and that we really don't want to. We don't want to pick a side. We want the legislature as a whole to say what its intentions are.
Well,
And
let
the
me ask you
statute
this.
does not do that.
Is
It
there
may
going to
be
be a,
that- I'm sorry,
I'm
let me
sorry.
say another thing, I'm sorry. It may be that when the hearings were taking place way back when the statute was passed, it may be that it was clear on your end what the intent was, but what the statute says is what it says, and that's the problem.
let me ask you this. Is there going to be a session?
That's a very good question, Ed. I hope so. I know they plan on it. Obviously, we're living in a world right now where things can change. So I don't know. I know the plan is for there absolutely to be a session. I'm sure that they're trying to figure out if there are spikes in numbers in a way that they think it is unsafe, I'm sure are trying to figure out contingency plans so that they can have a session, because, there's a lot of stuff that was left on the table last session, not just this issue.
Well, I know we won't be a top priority, but I would like to know from you, since you are associated with that, could I get a list of the legislators that are on that law committee personally?
The General Law Committee, it's online. It's very
Pardon?
easy to find. I can send you the link, Ed, but
I'd appreciate it.
but hold on, there's an election going on right now. It will change probably because they have an election coming up. So, at the beginning of every odd numbered year, because they're 2-year cycles, the leadership makes their committee assignments for that 2-year term. And
So that won't be till 21?
that will happen it will happen somewhere between December and the very beginning of January when they're sworn in.
Thank you.
So my next question would be in regards to the November 17th minutes, when we were told that until this problem is resolved, that relative to glass modular walls, the department will follow their current policy, which requires a license for this type of work. Is that still on the is that still the status quo?
At this point, what we're doing is that we're going to be looking at the cases, and if it is work related to furniture packages, there's still some lack of clarity, but we have said that in the past that at least some of this work is going to be licensable work. It is still unclear to us. However, there's a difference between whether or not something is licensable work and whether or not we will take it forward in terms of enforcement action. And if it's not a case that's deemed a threat to public health and safety, where the department would take an action on it, then we're in a tricky situation, because we can say, this appears to be licensable work, follow compliance with the law. Then someone says, pound sand, we disagree, then we think that there's a point of confusion there. And if this is not something that is an egregious violation of public health or violation of law related to public health and safety, then it's not a case we're going to bring forward. And one of the things that I'm very sensitive to is how the department is shown in terms, or seen in terms of our enforcement power and basically our follow through. I don't like to bluff. If we are telling someone that they're in violation of law, I want to make sure that there's some follow through. And so that's where, you know, we have a lot of communication with our investigators, and they'll say, okay, well, you know, we're thinking about bringing this case forward. You know, if we do so, what's legal's take on this? And so, you know, they are very thorough with how they're vetting this. And that's where, in terms of what Leslie said before, I need to know what the legislature intended so that then I can ensure that I'm appropriately enforcing the law as they envision it.
So we do not know for sure. We have to still look this up. We do not know if that job site was officially inspected or if it was. Our whole point of this meeting was actually to understand how the department made that determination. We wanted to see what sort of documentation Transwall provided to the department. So as to how you came up with the determination you came up with. And I feel like we're avoiding that answer. We don't seem to know if we were at that site or not. We know if the site was inspected, you may have changed your opinion. Our board is actually here to help the department enforce the laws that are on the books. But I think a lot of our board would agree with me when they feel like we're the enemies here, that the department's listening to everybody else but the people in the trade. So
well, I think first of all, so Pam,
in a bad spot.
So I'd like Pam or Janita to answer the question about the inspection part. But I can say in terms of, you know, feeling like we have adverse positions on this, I think the thing that we're looking for is for the board to be advocates to the lawmakers about what the industry needs and wants. And that's what we're really looking for, is that, you know, we want the board to take this to a higher level. You know, you don't report to DCP. You're all in appointed positions because you're professionals in the field with expertise. And that's where your input related to policy is critical. And so that's where we'd like you guys to take this, is to provide input at the highest level. But in terms of the inspection, actually how that played out, I don't know if Pam or Janita, you'd like to speak to that.
Good morning. This is Supervising Special Investigator Janita Hamill. I've had my hand raised attempting to answer that question, but nobody's called on me. So apologies for that. And in answer to the question for Mr. Von Dassel and Ms. Russell Van Nesse and Mr. Fusco, there was never a complaint submitted to the department. There was not an inspection done. One of the possible subcontractors contacted the department with questions about whether or not this would be licensable, and provided, I believe, a photograph and some documentation, which and the department is frustrated. And I want everyone to know that myself and my staff are just as frustrated as the legal department, our legislative department, the board. We're frustrated too, because we're the people that are out there on the sites getting the information. We're neutral and partial fact finders. And when we're not sure, we come back looking for answers. And as Mr. Fusco knows, this has been a 17-year process trying to get everything together and in writing. So for this, there was no inspection. This was before the work was even happening and the information came in. And the miscommunication was based on the fact that we were unaware of a 2017 board meeting minutes, and miscommunication came through that way. You know, we're not trying to be the enemy to the board or anyone else. We're just looking for guidance and assistance to be able to go out, to do our job and say flat out, no, I'm sorry, here it is in the statute, right here, or here's the reg, no, right here, and we're good. You know, I thought we were going in the right direction in 2014 when Mr. Fizzino came in with show and tell when we were working for Mr. Maloney before we moved to 450. And I thought regulations were coming then.
Well,
So-
we did them and then we did them and submitted them and then it got ixnayed.
Well, unfortunately,
We didn't get
that's,
to have our due process. Unfortunately, it got stopped because
Well,
of the time red thread.
I just want to speak to that because that's not entirely what happened here. What happened was I was newer to DCP at that point in time. We were working on a whole slew of regulations. This was one that, as you know, because you'd been working on it with Maloney, with Mr. Maloney, was in the pipeline. So then when we started to review it, we had, it was at a time when Julianne and I were newer than we are today to the agency. We put it in like we did a ton of different regulations at that time. We were just doing all sorts of things to submit regs that the agency was behind in. And so once it was out there, while that was happening, we were getting more information and recognized it was not as simple as we thought it was based on meetings we were taking and phone calls we were getting from people in the trades. And so then we realized whatever we submitted, we were making a policy decision or adopting a decision that we were putting before regs review that was, you know, picking so-called winners and losers in the industry. And we realized that that really wasn't our role. We realized it through two processes. One was the feedback we were getting when we put the original language, started to put the original language through that you had all worked with Maloney on. And then when we heard that there were issues and Julianne attempted to clarify things based on what we thought the intent of the statute was, and then you were all upset. And then that's when we said, oh, wait a minute, there's an issue here. And it goes way beyond us as a regulatory agency to determine how to address it. So it is really, we need more clarification from the legislature about what their intent is here. And that, so it was not, you know, that we were, that's what happened. You know, well, that's it. That's what happened.
So
Wait, can we go back to Janita?
Yeah, I was gonna touch on Leslie's point. When Ed, when you and I met with Richard Maloney at the time, which was in 2017, and put through our regulations, then we found out a memorandum was written and the regulations never got put in place.
Again, I just explained what happened.
Yeah,
We put them in along with dozens of other proposed regulations from the department that where everything had been in, you know, logjam. And then after we had feedback from people, both people who share your policy beliefs about this issue and people who don't. And through that process, there was more research done. And then the reg was revised in a way that you didn't like. And that's when we realized that we weren't going to get anywhere without getting more input from the legislature about what the intent was.
okay. But the concern is that you're telling us as the board professionals to go and to clarify, and then we try to, and then because it causes
We're telling you I'm
want us
sorry, Jennifer, I'm sorry to interrupt.
Yeah.
We're telling you that we need the legislature as the policymakers to tell us, and on your end, we're telling you all that you should talk with them and explain to them why you think the clarification should be what you think it should be. That's what we're telling you.
We understand that. And
Okay,
we know that I have to talk to somebody in 2021, which is hopefully a
Correct.
few months from now.
let's
I'd
hope.
like to go back to Janita, let her finish what she was explaining to us. Janita, you still there?
Yes, sir. No, I'm done.
Okay,
I just want to make it clear that we are not the enemy to the board, and we
We
don't
un-
consider the board the enemy either. We're all just looking for the same thing. And unfortunately, like Leslie said, you got to get legislators involved. But
thank you.
that's it. So, thank you.
You're welcome, Janita. Joe?
Yeah, thanks, Eddie. I just want to say that we had a meeting with Mike D'Agostino, who's the chair for the General Law Committee. And he indicated to us and the other people that had some stakeholding in this, that he believes that the clarification should come through DCP. He was confused why we were being pushed to him. So it's been a runaround. We're chasing our tail here. I don't understand. You don't want to do it. They don't want to do it. We're going in circles here.
You know, I'm sorry, Joe, but with all due respect, we are not the policymakers. We are the regulators. They
I
tell
get
us what
that,
the laws
Leslie.
are. we
I'm
enforce
just
them.
telling you what I'm being told from the
I
other
understand,
side.
and I'm sorry. Again, I'm telling you, and honestly, and I said this earlier, and I'll say it again. I don't think anyone wants to pick a side here, and that's the challenge we all face. And
Leslie?
frankly, if there was a way to get everyone in the industry to come to some kind of an agreement, that would probably help to do this. But that's what's going on, and I think you know that's what's going on.
Leslie,
Okay, I mean,
Take a
I'm
breath,
sorry, Eddie.
Leslie.
Can I
Sorry.
just 2 more
Both of you, take a
seconds?
breath, okay? We all are frustrated. But as
I
Joe
just-
said, we're chasing our tail here. And we understand what you're saying, Leslie, because we understand you have to regulate it. But when the lawmakers tell us, oh, go back to the regulator, what are we supposed to do? We go back to you and we frustrate you
Why do
even
you
more.
think why do you think they want us to make the decision and they don't want to make the decision?
Because they don't want a part of it. They don't want to be
Right.
part of it. They don't want to
Okay.
wash their hands.
They don't want to have to pick winners and losers.
We understand that.
Yeah.
But that's their job to pick winners and losers.
Well,
Because they're all
Well,
going to
the
be losers
winners
come
would be
November.
the winners are the public and public safety. So I don't understand why there's winners
I'll say-
and losers.
right. I just want to say one thing here because I don't want to just beat up on I don't want to beat up on the legislature. I think that I've worked with legislators for my almost entire career, and it is not always easy when you have competing interests like this. And I think, again, you know, what happens often in situations like this, and I've dealt with this in many other instances, is, you know, that they will tell you, go and figure this out with the people who are on the other side of the issue and come to some kind of agreement. And, you know, because at the end of the day, you feel strongly one way. There are those who feel strongly the other way. And if you all could come to an agreement, that's really the best way to do this. I mean, you and the others who disagree with you, one way or the other, you're the trades experts. I'm not going to get into who knows more about what thing, because again, then we get back into the circular discussion. But so getting you all to come to an agreement is probably the best way to resolve this, so that the lawmakers aren't put in this difficult position to hear out both sides. And then, you know, that's my advice.
But it's difficult for us all to come to an agreement with someone that doesn't know the craft as we know it, and as we put our training efforts into it. So if we say to someone that doesn't know the craft, say, you know what, we're going to do this for you. We're going to go give you one journeyman licensed by the state and one person that is not licensed by the state to do this work. So the guy with the license can say, I'm paying $125 or $150 a year for a license, and I'm working with this guy that doesn't pay 10 cents. That's his first argument, other than the training. And I know I don't want to frustrate you anymore, Leslie, okay? But that's what's going to happen. I've been there.
You guys are looking at it from, you know, the unit, whose work is whose work. The policy that we've adopted by letting these people do this glazing work has changed the definition of glazing. I'm a non-union guy. I have a non-union shop. I don't fight for work. I don't this and that. This is about public safety and the ability to install glass into frames on a job site. There should be, anyway, that you can't change the definition of what it is. The law was written, the statute was written about glazing, pre-glazed, not pre-glazed. It's pretty cut and dry. And I don't understand, because I'm not a big business guy or whatever, that we're talking about the wrong issues. But that's just my 2 cents.
Eddie, can I get 2 seconds still?
Yes, I have, go ahead, go ahead.
All right, I just wanted to say that on this one job charter, we're essentially talking about storefront framing. It's the same situation, storefront on the outside of the building. If you were putting it in, you need a license to do it. But because it's inside and they put it in a furniture package, all of a sudden you're saying now they don't need it. It's the same system. It doesn't make any sense to me. Whether it's inside the building or outside the building, it still has to be installed correctly. It still has to follow all the engineering and you know that it needs to go in to keep the people safe. It's the same system. So I don't understand. If you decide that the storefront inside doesn't need it, what's next? The storefront outside's not going to need it if they put a polished edge on it. No longer does it need a license out there anymore. So you guys, by making these little simple things, you guys want to, you know, you seem to want to cater to the guy who's ignored the license for 20 years. That's what's happened here. They've been working behind the scenes because we haven't had enough enforcement to go after them. And they've been doing it and doing it and doing it. Now they think, oh, well, we've been doing it. You don't need a license for that. We call it furniture. It doesn't, it's the same thing. We've been doing this as glazers forever. Interior storefronts, interior glass walls are always been part of the glazing package, always, until they changed this thing for tax reasons. These are just, they put another name to it and it's still glazing. The frame systems go in, the glass gets glazed into it. Still have to follow all the engineering, all the codes have to be met, just like the outside. So that's my 2 cents.
Thank you, Joe. It seems that we're preaching to the choir because it looks like everybody else is off here. I'm not sure how to operate this. I see I got participants 22. I don't know if I hit that and I'll catch a lot of people on the screen, or if I hit the arrow and just keep on moving. So we know we have to go to the legislature. It won't be till 2021.
Is that something that our flat glass board can do, or is it something that, or is that something where we need to go through a lobbyist and all this other stuff? I mean, why is there some help that our board has with helping to put this stuff through, so that instead of it coming from a union or non-union shop, this bill or change to the bill can be sponsored from our board and not from just, you know, one side of the or the other, whatever, just that it's our board, the SMEs, the people who are picked because of our knowledge are the ones who say, listen, the department of DCP has come to us, they can't enforce it. We as a board need to put forward XYZ. Or are we responsible on our own to try to pay a lobbyist to try to push this through? Would this have more clout if it came from the board directly or through the department, as opposed to one side of the aisle or the other, if you will?
Any comment, Leslie?
I think Leslie stepped away, but I think what we've emphasized in the past is that the department will not be taking a stance on this. That this is something that policy-wise. Oh, go ahead. She's
okay.
Right. I will absolutely say to anyone who asks and encourage the legislature to make clarifying changes to this language so that we know what to enforce and what not to.
But when
the question was, do we have to go after to do this individually, or as a board, or as contractors? That's the question.
You can do it all of the above. You can do it as a board. You can do it as contractors. You can all of the above, but you can do it as a board.
So how do we do it as a board? We have to hire somebody to do this, or how? I mean, how does this Say we
What's the
don't work,
process?
and you want to put,
I'm confused because I know Kim's somewhere and I don't want to put her on the spot. Sorry, Kim. I see your name though on the screen. I don't know if someone could recognize her,
Our
but and I
legislative
know,
liaison.
and I also know that John Bailey is somehow doing lobbying too for this industry, right? So,
right, well, what I'm saying
Yeah.
is we have the Connecticut Glass Dealers Association, which is a independent organization. We
and
have,
is that who John lobbies for? Sorry.
yes,
Okay.
yeah, and then you have Kim Glassman,
Right.
who's for the
Who's here.
fair contract, yeah. So what I'm saying is the department is DCP. We don't work, if you will, for DCP. We're appointed by the governor, we're SMEs, et cetera. So do we, when you're saying that we have to be the ones to get this momentum going to change the bill, what you're saying is it's either going to have to be the union putting, if you will, the fair contracting, Kim Glassman, or CGDA coming through and trying to put it in. So now it's making it look like a trade war, as opposed to our board as professionals saying, listen, this is a problem. Here's the history timeline of the past 17 years. We need to get this addressed. It seems like it would have more neutrality, more clout coming from our automotive flat glass board than it would from a union or non-union lobbyist.
You're free as a board to also go and meet with General Assembly, with members, with the General Law Committee, and to do whatever you want as a board as well. We cannot take a position on this, or we won't take a position on it. In fairness to everybody, we need to let this all get resolved. I have to get on, I'm sorry I don't want to leave, and I'm sorry to do this, but I have a meeting at 10 o'clock that I'm now late for. But at the end of the day, the board is free to also lobby on this.
Leslie, let me just interject for just 1 second. So one thing I did do is I put in the chat, and then I also emailed out the General Law Committee website. So you'll have the email addresses for all of the committee members there.
Yeah.
So
Again,
you don't have to go stand in a hall. You can send them emails.
Right, but again, they're I don't know what's happening next session yet. You know, we don't. Those are not they will not all be the same members next session. But nevertheless, you're free as a board to do this as well. I don't. You know, we can't do it as a department, because then we will be. We want to stay out of.
We're not asking you, we just needed guidance, that's all.
Yep. I'm
You've
happy
been
to.
guiding us for the last few years, last 17 years. We're asking for guidance now, and that's it.
Yeah, and I'm happy once we know who you can start to reach out to people now. I have to go though, because I have people waiting in the Teams lobby for a liquor meeting. So I'm sorry, but
Have a nice day,
I'm happy.
Leslie.
I'll be happy to pass along information. And I'm sorry, Kim, because I see she's unmuted and I'm taking off now. But thank you for unmuting Kim and being willing to jump in. Feel free to email me or give me a call. I am happy to answer any questions about the legislative process.
Thank you.
Okay, bye-bye.
Thank you.
Hi, this is Kimberly Glassman, Director of the Foundation for Fair Contracting. I do represent a number of both labor organizations of the building trades, construction trade unions, including the Painters and Glazers District Council 11, as well as different contractor associations as well. In this particular, with regard to this issue and the definition of pre-glazed, my lobbying efforts have been solely on behalf of my labor affiliate, District Council 11. That being said, I want to be helpful, and Jennifer, you are 100% right that this effort is better led, this conversation is better led by the by this body, by this board, than by any one individual interest or stakeholder. And so I'm certainly happy to schedule a meeting for the board, or at least the the co-chairs, Ed and Jennifer, and any board member who has the ability to attend, but I'm certainly happy to help facilitate a meeting with the chairs and ranking members of the General Law Committee. So you're meeting with the leadership of that committee on both sides of the aisle to discuss this issue. I also think it would be helpful to meet with the administration for you to sit down with the governor's office about this as well, because I disagree personally, and on behalf of my organization, I disagree with DCP's stance here. I disagree that DCP is kicking this to the legislature. And in fact, to Joe's point, he indicated, and Jennifer, I think you were a part of this particular meeting where the chair of the General Law Committee felt that that the agency should be making this determination through the regulatory process.
Yeah, and he
So,
was actually going to reach out to the DCP to
Right.
talk to them about it. And I
Right.
don't know if he ever did, but he was supposed to. He was concerned by the stuff we were telling him, and he was supposed to reach out to DCP. So,
I'm sorry, just to clarify, who was supposed to reach out to DCP?
Chairman D'Agostino.
yeah, D'Agostino.
So, sir, I'm certainly happy to help do that, and Ed, Jennifer, or any other member of the board, if you want to talk offline, or John Bailey and I can talk with you folks together, however you want to do that. Thanks.
Thank you, Kimberly. Excuse me. Julianne, a law question.
Yes.
If we do happen to have this conversation, are we required to publicly notify the public?
Yes, because despite.
If it's more than
regardless
3
of-
people?
Yeah, so you're going to be, regardless of whom else is going to be attending outside of the board, it would be considered a meeting of the board that would have to be publicly notified and posted on the Secretary of State site.
If it's more than how many? 2?
So it's going to be more than, I have to remind myself whether it says a quorum or whether it's let me go check right now, just with a specific language.
And that's just specific to the board?
That's specific to the board, yes.
Because I would like to be clear on this before we rush in and get our hopes up of meeting with some legislators. And then all of a sudden we find out, well, you can't do that without public notice. I have a question since I'm new to this. I have a blue arrow on my screen next to Jason. If I punch that in, will that give me everybody that's here? Or do I do gallery view?
If you go to the bottom of the screen and click on participants,
Yep.
and you'll be able to see everyone. It'll show up in a bar on the right-hand side.
Thank you. Excuse me.
I was lucky enough to wake up with no electricity this morning. So I have, we have Zoom Central in the other room, big screen TV. I can share everything. We can do all this stuff. So I started on my iPhone this morning, which was about that big. And I managed to get the meeting up on my iPad, but I still have no power.
So yes, I did confirm that it is a quorum of the board.
Of 4.
So this would be a majority of the board.
So 3 or less.
3 or less is the majority?
No, 3 or less, we don't have to publicly notify.
Okay.
So you have 6 members right now currently, correct?
Okay.
So if it's 3,
Well, we have a
you're
public
still,
member who doesn't show up and hasn't in probably 7 years, but he's still on there.
yes, but so if you have 3 members of your board, this should be publicly noticed.
Okay.
Also, you got to take in consideration that the law was changed where a quorum of the board is 40% for the OC boards under 393.
Okay.
Morning, Richard.
Good morning. I've been listening, don't worry.
You're always listening.
The only thing that I recall back in '99 was that one of the reasons the Home Improvement Contractors Association and the New Home Builder Association was upset is because when a person puts in a residential shower stall, the residential shower stall includes polished edge glass, and they didn't want someone to construe that they had to have a license. So the exemption was put in Chapter 393 to exempt 30 square feet or smaller if you have a home improvement contractor registration. So that was one example that was given to us back in '99.
Right.
So who's up here?
Well, Jessica was trying to talk, but I guess her mic is not working, so.
Kimberly,
You'll
are
have
you
to
still?
say. Oh, Jessica wants to know, she just typed in the side, it was, Richard, was that for sliding glass doors? That was for sliding glass doors also.
Right. Anything 30 square feet or less that's not otherwise pre-glazed, if you hold a home improvement contractor registration and you're doing residential work or a new home builder registration, you're exempt from the license and law for glaziers.
Yeah, and ironically, I hold an FG1 license for my glass side, and I also have to have a home improvement contractor's registration for the residential side of the work that we do. So my glazer's license doesn't cover the work that I do in the residential side. So I have to actually have both, ironically.
Well, because you also install pre-glazed window units.
No, we don't actually, not in residential.
You don't?
No.
Then you're probably exempt from the Home Improvement Act, because there's an exemption in the Home Improvement Act that exempts people that are otherwise licensed for what they're working on.
Yeah, well, we were always told by the department that we had to have it, so I just renew it every year to cover myself just in case. So I'd rather pay the $200 or whatever it is than get slapped with a fine.
Any more questions or concerns? Because as we know, we have to go through the legislator to.
Is there any way that our board can open up a complaint against that case in Norwalk, that Norwalk Glass is at or not doing, or have a site inspection since it wasn't officially an opened case? Is there any way that that site can be inspected? Because if nothing else, it might be a good educational field trip for the department to see what exactly it is.
So there was.
I mean, we're there. I'm willing to document everything that's going on. I mean, I don't know if pictures will help for consumer protection.
Videos might help as well, but I mean, it might be beneficial for the
Yeah, I mean,
department.
I can document their system, how they're installing their system, which is technically demountable or furniture vendor in people's eyes. And then I could document, one of the systems that we install, which is pretty much identical. So they could see apples to apples, what the scope of work is that we're saying it requires a license.
So here's the thing though, is that there was a case that it was looked into by the department. And so there was certainly communication with Transwall, as you all know, there to get further information about the project. It doesn't seem like we fundamentally don't understand the work that was going on there. What it appears is that we fundamentally disagree as to whether or not this is a public health and safety issue that rises to the level of conducting enforcement. And so, as I've said, since it appears that we are clear on both your end and our end what work was being done, it's only the difference of what should be done about it. I don't necessarily know that the additional information would be helpful to our investigation staff, but by all means, you can certainly send things in. But lodging an additional complaint based on the work that we're already aware of wouldn't necessarily be fruitful, since we already have a case that we looked into related to this same work.
Thank you,
I
Julian.
would document and video whatever you can, because we're obviously going to need it for when we meet with the lawmakers.
Yeah, I'll get some stuff for us moving forward.
Maybe
just so we have it.
maybe the strategy should be to go to the bean counters and tell the IRS that this is not office furniture and it's being misclassified, and get them to get some more tax money, and maybe that will stimulate or fix the problem instead of going the way we're trying. Maybe we're looking at this from the wrong angle.
Yeah, I mean, I've seen channel set glass being classified as demonible. So realistically, I think it's what the architects decide they want to call it and what the accountants want to do with it.
Yep. Yep.
Thank you, Mark, for that. Any further business? Carl, Jennifer, Joe, Julianne?
No,
No?
thank you, sir.
Can you hear me?
Yes, I can hear you, Carl. And I can also see you.
I think this is John.
Oh, John.
Oh, John, I'm sorry.
Talking.
No, just a reminder that I asked for the next meeting was the, I think it was the minutes that DCP was gonna, on the auto glass side, was, wanted to defer to us, and I think they said they weren't in favor of having people come in from the outside in the case of an emergency. I just wanted to get those on the next minute since we had this meeting. I know.
Julian, are you aware of that question that John's asking?
No, I'm not familiar. If you can clarify, that'd be great.
John?
So I believe last meeting, or there was a meeting, last meeting, we talked a lot about the auto glass and the bill that was in play, I believe by Safe Light, that once the if the governor were to create, say, a state of emergency, that would enact basically automatically anybody, or I guess to put this, would anywhere in the state, outside states or anything, could just flood the state of Connecticut to do auto glass. And there's opposition to that bill, many opposition from obviously glass companies within the Auto Glass Safety Council, AGRIS, the Connecticut Glass Dealers Association. There's quite a few people, and there was a statement made by, I believe, DCP. I think it was like 2 meetings before that they told Safe Light that they weren't in favor, and the board offered to work with them to try and find some common ground. And I think DCP also told them to go towards the board on this. And I just asked for somebody to research those minutes and put it in the next meeting. But this meeting was kind of an impromptu meeting, I guess. So we didn't get into it.
The meeting minutes, the meeting prior, Richard, tell me if I'm speaking out of turn, but they should be, aren't those published on the website, or are they just sent out to the board subsequent to the meeting?
Well, if it was for the last meeting, they're still in a draft form.
No, the one from
So
2
we don't-
meetings ago.
Then that should be on the website, yeah.
Okay, I'm just checking now. Let's see.
But what it was proposed legislation, and it didn't go any place because of the COVID matter.
Yeah.
So unless it gets raised again, or they bring it up again, it's kind of a moot issue.
Oops, hold on. I have Ed speaking on my other screen. Hold on. Okay. Yeah, so I'm just looking at it. It is, so the recording is on our website, that the live stream for YouTube for the meeting recordings, and then for the meeting minutes. For the meeting minutes for September are not yet published on our website, but we can make sure that those are up there for the, oh wait, that's for, hold on, that's for the September meeting. No, the meeting before that, sorry, was July. That's what we're talking about. So the July meeting minutes are on there, excuse me. And so you can, if you go on the DCP website, that's right there, talking about the bill that was raised 5294, and it does note that you and Ed Fusco were opposed to the bill, And that Leslie O'Brien says that no action was taken on this bill during this due to the shortened session. However, John would continue to follow up with the lobbyist on this matter. That's what the minutes say. And so actually, let me see. Oh, I can't share my screen right now, but oh, here, let me just if you go into the chat function, then I just sent the link in there so you guys can all easily go access those meeting minutes.
So as it stands right now, there's nothing being done, John, about this, and until legislature changes and they pick it back up in 2021, it's going to sit there.
Yes, no, I understand that. I think the only reason I asked for those minutes to reflect what was said in July, and I didn't see it in the text, was because originally, I think when this came up, when they wanted to do this bill, I think DCP at that point said they had no stance. And then in conversations, it was, I believe it was July, you know, for lack of a better word, I think they kind of did have a stance or changed it a little bit in saying, we'd rather have you go with the board and work through the board to get this done. So that was kind of significant for me, looking at it as a little bit of a change, I guess, or a little bit of a stance.
One of the things that we commonly say is, especially if we don't have an opinion on the matter, if there is no significant operational impact on DCP, but there's a board that oversees the subject, for example, you know, architects or plumbers, will say, you know, and there is an entire group of people that are appointed to serve as policymakers and, you know, dealing with licensing and enforcement issues that are either appointed by the governor or names set forth by the legislature. Therefore, go to these people who are experts in the field to get their sign off and their input. Because if it's something that doesn't really impact us operationally, we're not the policymakers. So if they're trying to change policy, then it makes most sense to go talk to the people in the industry, which are our board members. So that's why we oftentimes refer people over to the boards.
And thank you for that, and I totally agree with you. But I think that the original bill, it was it appeared that they were trying to do an end around the board, and you know, I think it was appreciated that legal said, "Hey, look, we think you should work with the board on this." There's also another concern that they're just keeping an eye that it might try and get snuck into another bill if legislation does open. But there's nothing to report right now.
You all set, John? Did you get the link to see the minutes?
No, I'll look at them I saw them last time and I remember asking, but I'll look at them again. Thank you.
Anyone else? Well, since we're all done with this session, can I get a motion to adjourn this meeting?
I can make it.
I'll make a motion to adjourn.
Carl?
That would be.
John, you making a motion?
Yeah, I'll make an emotion to adjourn this meeting.
Can I get a second?
I'll second.
I'll second it.
All in favor?
Bye.
Thank you.
Aye.
Bye.
Bye. Goodbye, Julian. Thank you for your time.
All I can say is, wow.
That's all I can say.
I'm trying to find a way.
I just don't understand at 450 Columbus Boulevard.